Delhi Rent Control Act is a special enactment enacted by the Parliament in the year 1958. This act governs the rent law in Delhi. This is basically a social legislation. Now, the question arises, what is social legislation? A legislation which achieves the goal for a state to become it a social welfare state. In the democratic welfare principle, a state has certain obligation towards its citizen. To achieve that obligation, states enact the law. State made the law. That law is called the social legislation. The purpose and objective behind this legislation of Delhi Rent Control Act is that to give shelter to those who doesn't have roof on their head. After the partition, when herd of the people came and arrived in Delhi, to give shelter to those, to protect their right, this law was enacted. That is called Delhi Rent Control Act. It's governed the relationship between the landlord and tenant in Delhi. But unlike the Transfer of Property Act, the Delhi Rent Control Act has certain feature in it. Sometimes it is called, this Delhi Rent Control Act is pro-tenant. Why it is called pro-tenant? Because it gives special privileges to the tenant. How it happened? See, the relationship between the tenant and landlord is a relation which emerged by contract between them. Either it can be reduced in writing or it can be oral also. So, the tenancy between the landlord and tenant is a contractual. It is a contract between the two. In the Delhi Rent Control Act, yes, it is also a contract. But if the contract ceases to exist, then the tenant is protected by the statute. He became a statutory tenant. This is a special provision in the Delhi Rent Control Act, where a tenant is a statutory tenant also, even after expiry of the contract. Despite of being it called a tenant friendly, the legislature has established a balance between these two. We will see further how the landlord right is being protected under this act as well as the tenant's right. For examination point of view, the Delhi Rent Control Act, only one section that is important which covers 75% part of the syllabus, that is section 14. This section 14 envisages the protection of tenant from eviction. Vice versa, if it protects tenant rights, it gives entitlement to landlord that how the eviction can be secured from the tenant. Delhi Rent Control Act laid down certain rules under which only a landlord of the premises or the owner of the premises can secure the eviction. That rule and regulation has been envisaged in section 14 only. If the tenant has failed to make the payment of the rent, then the landlord can secure the eviction. If the landlord having the bona fide requirement for himself or his family members, he can secure the eviction. Or tenant has acquired another premises, that can be a ground for eviction. If the tenant without the permission of the landlord has sublet the premises, that can be a ground for eviction. Another, if the tenant has made addition and alteration in the premises concerned, landlord can ask the eviction. These are the grounds under which only a landlord or the owner of the premises can secure the eviction. So, in all these grounds, the most important ground is that bona fide requirement. Eviction of the tenanted premises from the tenant on the ground of bona fide requirement of the landlord or owner. In the section 14, subsection 1 and clause E talks about the bona fide requirement under which a landlord can secure the eviction from the tenant. That is the most important. If the section 14 covers the 75% of the syllabus, then section 14 subsection 1 and clause E covers almost half of them. What is the bona fide requirement? The bona fide requirement is that a landlord is having personal need of the premises which has been let out to the tenant for his personal use or for the use of his family members, either for the purpose of having residence or for commercial purpose. But when this requirement will be bona fide, the requirement must be genuine one. It is not the requirement which is the whims and fancy of the landlord. Interesting fact is that landlord can secure the eviction on the ground of bona fide requirement? No. A landlord necessarily has to be owner of the premises. Here, this is the exception of Section 116 of the Evidence Act, that is the law of estoppel. What is the law of estoppel? Law of estoppel is that if a tenant has attorned a person to his landlord for time immemorial, he cannot deny the status of that person of his landlord. But here in this case, as far as the eviction of the tenant under the ground of bona fide requirement is concerned, law of estoppel doesn't have any role to play here. So, what we learn that a landlord, if seeking eviction of the tenant on the ground of bona fide requirement envisaged under section 14, subsection 1 and clause E, necessarily he has to be owner of the premises. So, a owner, if he proves despite of being a landlord, suppose that he is not a landlord is some other person, even then that owner of the premises can secure the premises, can seek the eviction from the tenant under the bona fide requirement. Clear? Now, which premises can be a ground for eviction under the bona fide requirement? Initially, in the Act, only the residential premises can be the subject matter of eviction under the ground of bona fide requirement of owner or landlord owner. But Honorable Supreme Court in the judgment of Satyavati Sharma included the commercial premises also in the fold of eviction under the bona fide requirement. There is two types of premises which is generally let out to the tenant. First is the residential premises, where the premises is being used for the residence of tenant, or the commercial premises, that is the shop, offices, etc. Categorically, it is the broader definition which has been given by the Honorable Supreme Court in the Satyavati Sharma case, that the premises, not only the residential premises but as well as commercial premises, is also coming in the fold of the eviction under the ground of bona fide requirement. So, after the Satyavati Sharma, the commercial premises is also included in the bona fide requirement. The first thing we know that under the bona fide requirement, a landlord necessarily has to prove that he is the owner of the premises. Second, under the bona fide requirement, not only the residential premises but for the commercial premises, eviction can be sought. The second aspect of the eviction under the Delhi Rent Control Act is the service of notice. A landlord or the owner of the premises, if he is seeking eviction of tenant from the premises, he has to necessarily serve a notice to the tenant. That is notice generally under 106 of Transfer of Property Act. Notice under 106 of Transfer of Property Act by asking the tenant, hereby I am serving quit notice to you, you please vacate my premises and hand over the peaceful possession of premises to me, because I no longer want to keep you as a tenant in the premises. Tenancy ceases to exist by the two modes. First, by flux of time. Suppose that if there is a contract between the tenant and the landlord, that for particular period the inception of tenancy has taken place for that particular period, and that particular period has ceased to exist, that come to an end, the tenancy goes. And the second aspect is that service of notice. If during the period of tenancy, a landlord served a quit notice to the tenant under 106 of Transfer of Property Act that you vacate my premises, he has to vacate the premises under the Transfer of Property Act. But under the Delhi Rent Control Act, if a notice is being served upon the tenant asking him to vacate the premises, he is under legal obligation to vacate the premises? No. Why? Because statute protect that tenant. That statute is Delhi Rent Control Act. Delhi Rent Control Act gives protection to the tenant that merely because a notice served upon him by the landlord asking under 106 of Transfer of Property Act, asking him to vacate the premises, he is not under legal obligation to vacate the premises, because he has to be vacated by the ground which has been mentioned, which we have discussed earlier, the ground which is mentioned in section 14 of the Delhi Rent Control Act. Besides being the section 14, no other remedy available to the landlord to evict the tenant from the tenanted premises. And which portion of which tenancy comes under the Delhi Rent Control Act and which is Transfer of Property Act, that is also interesting to note. If a premises having rent of 3,500 rupees, that comes under the Delhi Rent Control Act. Delhi Rent Control Act fixes a monetary upper limit to be a tenant under the Act, that if a tenancy, if the consideration amount, that is the rent, is more than 3,500 rupees, then that tenant is having no protection under the Delhi Rent Control Act. The tenancy between the landlord and the tenant, if the rent is above 3,500 rupees, then the tenancy between the landlord and the tenant is governed by the Transfer of Property Act. In that case, the tenant will not have protection, which protection generally tenant have in the Delhi Rent Control Act. So we were talking about the service of 106 notice. So merely service of notice under 106 of Transfer of Property Act by the landlord to the tenant, if the rent is less than 3,500, is not suffice to not created a ground in favor of landlord to ask eviction from the tenant. Under the Transfer of Property Act, if a notice under 106 of Transfer of Property Act is being served upon the tenant, and tenant in response to that notice has not vacated the premises under the time which has been given in the notice, that tenant is a unauthorized occupant. He will no longer having status of tenant of the premises. Instead, he will be called unauthorized occupant. His occupation is not authorized. The landlord has not given him permission to stay further in the premises, or permission has been withdrawn. That is basic essence of the service of notice. Very interesting fact about the Delhi Rent Control Act, whether the tenancy is inheritable. The question arose, a person who is the tenant of a premises, if his tenancy is protected under the Delhi Rent Control Act, whether he can execute a will by bequeathing his tenancy right to his successor. This is the question which is time and again is being asked. In the Delhi judicial examination, several times this question has been asked. If a person is a tenant of a premises governed under the Delhi Rent Control Act, whether that particular person can execute a will bequeathing his tenancy right in favor of beneficiary. This question has been answered by the Honorable Supreme Court in Gyan Devi case. In Gyan Devi case, it has been held that tenancy is inheritable, meaning thereby tenancy is a right created in the favor of tenant, and that right can be bequeathed by executing a will. Section 50 of the Delhi Rent Control Act. Section 50 says the jurisdiction of the civil court is barred under Section 50. If any dispute arose between the landlord and tenant, that will be adjudicated by the special court enacted under the Delhi Rent Control Act. Civil court generally doesn't have jurisdiction to entertain the dispute between the landlord and the tenant. The Section 50 is created a bar upon the civil court not to adjudicate the dispute between the landlord and tenant. I think by the strategic study, we can make the Delhi Rent Control Act easier one. It will grasp easily in the mind what is act about.